On this date, defendant Dennis Welk appeared in an Ohio courtroom for sentencing. Mr. Welk had previously pled guilty to Count 5 and Count 6, both charges of sexual battery, which are classified as felonies of the third degree under Ohio law. The victims in this case was a minor child, Mr. Welk's stepdaughter, making the nature of these offenses particularly egregious. Now, under Ohio Revised Code Section 2907.03, sexual battery is defined as engaging in sexual conduct with another person when the offender is the other person's natural or adoptive parent, step-parent, guardian, custodian, or person in loco parentis, meaning a person standing in the place of a parent. This statute exists specifically to address the inherent power imbalance between a caretaker and a child in their care. When a person occupies a position of trust and authority over a minor, the law recognizes that any sexual contact is inherently coercive, regardless of whether physical force was used. As a felony of the third degree in Ohio, sexual battery carries a prison term of 9 to 36 months for each count under Ohio Revised Code Section 2929.14. However, the court has discretion to impose sentences for multiple counts, either concurrently, meaning they run at the same time, or consecutively, meaning they run one after the other. Here, the prosecution and the defense presented the court with a joint sentencing recommendation of 8 years, or 96 months. It is important to note that while joint recommendations carry significant weight, a judge is not bound by them and retains full discretion to impose a sentence within the statutory range that the court deems appropriate. Prior to sentencing, the court had ordered a pre-sentence investigation report, commonly referred to as a PSI, as well as a victim impact statement. Under Ohio law, a PSI is prepared by the probation department and provides the judge with a comprehensive picture of the defendant, including criminal history, personal background, substance abuse issues, and an assessment of the risk the defendant poses to the community. A victim impact statement, authorized under Ohio Revised Code Section 2947.051, allows the victim or the victim's representative to describe the emotional, psychological, financial, and physical impact of the crime. Together, these documents are critical tools that help the court arrive at a sentence that reflects both the severity of the offense and the individual circumstances of the case.
Thank you, Your Honor. We are present in the state of Ohio versus Dennis Welk in case number 25-CR-206. The defendant is in court represented by counsel. We were last here on May 14th where the defendant pled guilty to Count 5 and Count 6, both being sexual battery felonies of the third degree. At that time, the court referred the defendant for a pre-sentence report and victim impact statement. Those reports have been completed and the state is prepared to proceed with sentencing.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'm going to be brief. This was a heinous crime, Judge. This was horrible in a lot of ways, but most importantly, because this was a minor child who almost assuredly didn't fully understand what was going on with somebody whom was entrusted to love her and to protect her. However, Your Honor, this is not indicative of who Mr. Welk is as a person. Yes, he has a record. Yes, he has been to prison, but it's mainly in the past been for drug offenses, I believe some theft offenses, nothing of this magnitude. On this day, and this is not an excuse, Judge, for his behavior, but on this day, Mr. Welk was drinking a lot, was highly intoxicated, and took advantage of his stepdaughter. Since the day I met him, he is in disbelief that he did this. He has expressed to me his remorse and his sadness, and how he hurt her, how he hurt his wife, how he hurt the rest of his family. He knows, Your Honor, that he's going to be spending a lot of time in jail coming up. I know there's discretion with the plea with how much time that equates to. This court has a lot of discretion with that. Earlier in chambers, the state and I presented to the court a joint recommendation for 8 years. I'm going to respectfully ask the court to consider imposing that sentence because I believe Mr. Welk is remorseful. I believe that this is not who he is as a person, and I'm hoping when his time is up and he gets out, which by the way, he's going to be reporting as a sex offender for the rest of his life, so he's going to be under a microscope, he's going to be monitored for the rest of his life, but I'm hoping that he'll be able to piece things together, make amends with at least part of his family. I don't know if he can ever make full amends with everybody or not. And you're going to hear from him in just a minute, Your Honor. But again, I don't think this is who he is as a person. And I'm going to respectfully ask the court to consider adopting the joint recommendation. Thank you, Your Honor.
All right. You are required to register in person with the sheriff of the county in which you establish a residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. Failure to register, failure to verify residence at the specified times, or failure to provide notice of change in residence address or other required information as described above will result in a criminal prosecution. Mr. Watson, if you would present this to Mr. Welk for his acknowledgement and signature. All right, Mr. Welk, what do you want to tell me before I impose sentence?
First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was a main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow, having to deal with that as a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day. Over this, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
What we're about to hear from the prosecutor is significant because it directly challenges the credibility of Mr. Welk's expressions of remorse. The prosecutor reveals that while Mr. Welk was incarcerated in the Lake County Jail awaiting disposition of this case, he continued to communicate with the minor victim, his stepdaughter. Now, in many jurisdictions, courts impose no contact orders as a condition of bond or pretrial release, specifically prohibiting the accused from having any direct or indirect contact with the alleged victim. This is particularly critical in cases involving minors, where the power dynamic between the accused and the victim creates an acute risk of witness intimidation or manipulation. Under Ohio Revised Code Section 2945.04 and related provisions, any attempt by a defendant to influence, threaten, or persuade a witness to alter their testimony or cooperation with law enforcement can constitute the separate offense of intimidation of a crime victim or witness, a felony of the 3rd degree. Here, the prosecutor alleges that Mr. Welk used jail phone calls, which are routinely recorded in county jails across Ohio and virtually every jurisdiction in the United States, to pressure the victim to communicate favorable sentiments about him to law enforcement and to express a desire that he receive a short sentence. The prosecutor further alleges that Mr. Welk attempted to guilt the victim by blaming her for his own suicide attempt while incarcerated. This type of conduct is a textbook example of what behavioral psychologists and domestic violence experts refer to as coercive control, a pattern of behavior in which an abuser uses emotional manipulation, guilt, blame shifting, and expressions of affection to maintain psychological dominance over the victim, even when physical access is restricted. The prosecutor also highlights a critical contradiction in Mr. Welk's case. While he stood before the court expressing remorse and taking responsibility, his pre-sentence investigation report told a very different story. According to the prosecutor, Mr. Welk stated in the PSI that he did not believe he did anything wrong and that he wanted to take the case to trial. This kind of inconsistency is exactly what judges look for when assessing whether a defendant's courtroom expressions of remorse are genuine or merely performative, a calculated attempt to garner sympathy and influence the court toward leniency.
Ms. Alessi?
Thank you, Your Honor. One thing that the defendant said today in court, and even in his pre-sentence report, that stood out to me is that he was supposed to be a loving and caring father. And I couldn't agree more with that. He should have been someone that the victim could trust and rely on for protection and guidance. And instead, he used his role as a parental figure to manipulate her, exploit her, and violate her. And while there is a jointly recommended sentence here, the state believes it's essential to highlight not only what the defendant did pre-indictment, but also what he did after his arrest in this case. While incarcerated, he continued to communicate with the victim while in the Lake County Jail. He attempted to guilt and manipulate her by blaming her for her own suicide attempt at the East Lake Jail. He pressured her to express her feelings to law enforcement about him or her desire for him to only receive a short sentence. He spoke of wanting to attend counseling together. He emphasized they were a team and told her he loved her, despite being her abuser, despite doing what he did here. And during several of these recorded calls, you can hear the victim crying, further illustrating just the ongoing emotional harm caused by the defendant and his conduct. This behavior demonstrates his continued disregard for the well-being of the victim, his family, and his ongoing efforts to control her and manipulate her. The defendant today in court said he's remorseful, but in the pre-sentence report, he didn't believe he did anything wrong, and he wants to take this to trial. So I'm not sure what this court can believe. He has a lengthy criminal history, including 4 prior prison numbers and 5 felony cases. And all of this, I think, supports the need for a significant term of incarceration, and respectfully ask this court to impose a jointly agreed sentence of 8 years. Thank you.
Thank you. Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her. I called my wife, and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her statement?
It wasn't retracting. It was we talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to, whether directly contacting her or contacting her through your wife, was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now, she had asked the detective if she could have contact with me when this case was all started. Then when I went to my preliminary hearing on February 11th, I asked the detective, and he told me the same thing.
All right. Well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. Okay. In talking to her, having about anything having to do with this case. So you've in your statement you say you apologize to her, but then in the pre-sentence report you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of. So I wasn't admitting to, I don't know what happened.
So did you or didn't you do this stuff?
Yes.
Okay. And I got to tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass and a habitation, breaking and entering, June 23 of 16 through August 5 of 18. A whole bunch of theft offenses between that last prison sentence and where you are today. So you've had a lifetime of criminal activity, but none worse than what has occurred here. So I've reviewed the pre-sentence report and a victim impact statement. I've considered what you have said, what counsel has said, and I've also considered that they've made a joint recommendation of 96 months in prison. And so on count, and I've considered all the provisions in 29, 29, 11, 29, 29, 12, 13, and 14. In consideration of all that, on count 5, I'm going to sentence you to a term of 60 months. On count 6, I'm going to sentence you to a term of 60 months that will be consecutive to one another, with credit for 143 days. And consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment.
All right, get out, man. Come on, man.
Sit
What the fuck
down.
you mean, man?
Stay down.
No, man. Get me the fuck out of here, man.
Judge.
You want fucking took my plea back, man. Get me the fuck out of here, man. Get me out of here. Get me out of here, man. Get me out of here, man.
Almost done, Judge.
Get me the fuck out of here.
And they
No, man. Get me out of here. Get me out of here, man. What the fuck you mean, nigga? Get me the fuck out of here. Man, get me the fuck out of here. Let me get my leg. Get me out of here, man.
Just take him in the chair.
Okay, we're in this chair.
All right.
I'm visiting tomorrow.
Put me on your visiting list for jail and for.
All right, man. Stop touching me, man. I'm not doing shit, man. I'm not doing shit. I'm not doing shit. What the fuck? Do all this or that?
All right, consecutive sentences are necessary to protect the public from future crime by the defendant and for appropriate punishment. And they are very proportionate to the seriousness of his conduct and the danger he poses to the public. And his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Costs are assessed, the remaining charges are dismissed. Anything else, Ms. Alessi?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
Judge
All right,
ultimately
adjourned.
determined that the jointly recommended sentence of 96 months or 8 years was insufficient given the totality of the circumstances. Instead, the court sentenced Mr. Welk to 60 months or 5 years on count 5 and 60 months on count 6 to be served consecutively for a total of 120 months or 10 years in prison, with credit for 143 days of time already served. Now, under Ohio Revised Code Section 2929.14c4, a court may impose consecutive sentences if it finds that consecutive sentences are necessary to protect the public from future crime or to punish the offender, that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and the danger the offender poses to the public, and that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public. The judge explicitly made these findings on the record, which is a statutory requirement. Without these findings, consecutive sentences can be reversed on appeal. The court pointed to Mr. Welk's extensive criminal history as a key factor in his decision. The record shows that Mr. Welk had 4 prior prison commitments and 5 felony cases, including burglary, attempted burglary, trespassing in a habitation, breaking and entering, and numerous theft offenses spanning years. The judge noted that Mr. Welk had previously been granted judicial release, which is Ohio's equivalent of early release from prison subject to community supervision, and had violated the conditions of that release and been returned to prison. This history of repeated incarceration, release, and reoffending demonstrated to the court that Mr. Welk had been given multiple opportunities at rehabilitation and had failed to take advantage of any of them. What followed the sentencing was a dramatic courtroom outburst. Mr. Welk erupted in profanity, shouting at officers and demanding to be removed from the courtroom. This reaction is telling for several reasons. Throughout the proceedings, Mr. Welk presented himself as remorseful, contrite, and willing to accept responsibility. But the moment the court imposed a sentence 2 years beyond the joint recommendation, that facade shattered entirely. His reaction was not that of a man who understood the gravity of what he had done to his stepdaughter. It was the reaction of someone who was only sorry that the consequences were greater than he had been led to expect. Additionally, as part of his sentence, Mr. Welk is required to register as a sex offender for the remainder of his life under Ohio's version of the Sex Offender Registration and Notification Act, commonly known as SORN, codified in Ohio Revised Code Chapter 2950. This means that upon his release from prison, Mr. Welk will be required to register in person with the sheriff of every county in which he resides, works, or attends school. He will be required to verify his address at regular intervals, and any failure to register or to notify authorities of changes in his information will constitute a separate criminal offense. Sex offender registration is a lifetime obligation that significantly restricts where an individual can live, work, and travel, and it serves as a permanent public record of the conviction. This case serves as a stark reminder of the devastating consequences when a person entrusted with the care and protection of a child instead chooses to exploit that trust. The criminal justice system exists, in part, to ensure that the most vulnerable members of society, especially children, are afforded the protections they deserve. When those protections fail at the individual level, it falls to the courts to impose consequences that reflect not only the severity of the crime, but also the need to protect the public and deter future offenders from committing similar acts.